The second read that we would like to discuss is Mandamus, and the very meaning and object of the writ of Mandamus is inform a command issued by the Supreme Court or the High Court to the government, and in case of Supreme Court, inferior court, even tribunal, public authority, corporation, or any other person having public duty to perform, asking such government, inferior court, tribunal, public authority, corporation, or person to perform public duty or to refrain from doing illegal act. For example, if the order of the tribunal is not implemented by the government, the mandamus may be issued by the court directing the government to do his legal duty by implementing the order. So, the mandamus may be issued by the court directing the government to do its legal duty by implementing the order. The mandamus may be issued to a corporation to carry out duties placed on it by statutes creating it. However, a company which is incorporated under the Indian Companies Act and has neither statutory duty nor public duty to perform, the mandamus cannot lie. So the main object of this writ is to compel the performance of public duties exercising as prescribed by the statute and keep the subordinate tribunals and officers exercising public functions within the limit of their jurisdiction. It is issued to secure the performance of a public duty in performance which the applicant has a substantial legal interest. Mandamus can be issued to any authority exercising public functioning. Thus, it can be issued to any authority, whether it exercises administrative, legislative, judicial, or quasi-judicial functioning, and the very conditions for the issue of the writ of mandamus, if it is a public duty, so the person or authority against whom this writ is sought to be issued must have public duties to perform, and there must have been failure on his part in performance of his duties. The duty will be public duty if it is created by a statute or rule of common law. Thus, the duty imposed by the Constitution, the statute, common law, or rules or orders having the force of law is regarded public duty. For the issue of this writ, it is necessary that the authority against whom it is issued must be a public authority. It may be issued even against a private body if the duty cast upon it is of a public nature. However, it cannot be issued against a private person or private body which does not perform public duty but performs only private duties. In the leading case, Vidadala Hari Nandababu versus N.T. Rama Rao in 1990, the Andhra Pradesh High Court has held that the code of conduct for ministers evolved by the union and the state are not statutory nature. They are in the nature of guidelines. They do not have constitutional or statutory sanctions and cannot be enforced by the court. So, how duties to be mandatory, then the very writ could be issued. So, the authority or the person against whom the writ is sought to be issued must have some public duties to perform. The performance of the duties by him must be imperative or mandatory and not discretionary, and there must be failure on his part in the performance of the duty. So, if the rule of the government is given a discretion to grant dearness allowance to employees, the writ of mandamus cannot be issued to compel the government to grant dearness allowance as it was decided in the leading case Manjula Manjari versus Director of Public Instruction in 1952 by the Odisha High Court. But the discretion is exercised bona fide and not arbitrary. The mandamus is not issued as it was decided in Vivekanand versus University College of Engineering, Burla in 1976 by the Odisha High Court. But if the discretion is exercised arbitrarily or maliciously or without applying the mind or on the irrelevant consideration, the mandamus will lie as it was decided in the leading cases Jawaharlal Nehru University versus Nariwal in 1980 by the Supreme Court and also in Nandalal versus Bar Council in 1981 by the Supreme Court. So also in Control of Estate Duty versus Prag Das in 1981 by the Supreme Court. So, if the authority is under duty to exercise its discretion, but it does not exercise discretion, the court may issue mandamus asking the authority to act according to law and exercise the discretion as it was decided in the leading case Commissioner of Police versus Govardhan Das in 1952 by the Supreme Court. And the Supreme Court in the leading case in Supreme Court Advocates on Records Association versus Union of India in 1993 has held that even if the duty is discretionary, a limited mandamus can be issued directing the public authority to exercise the discretion with a reasonable time in accordance with law. So also it can be issued if the petitioner's legal right to compel the performance of the duty is there. So the petitioner should have legal right to compel the authority or the person against whom he seeks the issue of the writ of mandamus to perform his public duty. The petitioner thus should have legal right to compel the performance of the public duty cast on the opponent. So also it can be issued when there is a demand of the performance and its refusal. For the issue of mandamus, it is necessary that the petitioner has called upon the authority concerned to perform its public duty, and the authority concerned has refused to do so. So, in that case, the very writ of mandamus can be issued as it was decided in the leading case, State of Haryana versus Chaman Lal in 1976 by the Supreme Court. And as regarding the alternative remedies, as in case of infringement of the right other than the fundamental right, the court may refuse to issue the writ if the effective and adequate alternative remedy exists. However, the existence of alternative remedy is a rule of discretion and not rule of law, and the existence of alternative remedy is not an absolute bar. And now we'll discuss regarding under what conditions a writ of mandamus can be refused, and those grounds that it cannot be sued for enforcement of private duties. It cannot be issued for the enforcement of obligations arising out of a contract. So it cannot be issued against the private body or private individual if it is not entrusted with any public duty. So it cannot be issued. The person or authority against whom the writ is sought to be issued must have some public duty to perform, and the performance of the public duty by him must be imperative or mandatory and not discretionary. If the duty is merely discretionary, the writ of mandamus cannot be issued to enforce it. However, if the discretion is exercised arbitrarily or maliciously or without applying the mind or on the irrelevant consideration, mandamus will lie. And the other ground, that is, the writ may be refused on the ground of leaches or on the ground of unexplained delay. So, if the petition for the writ of mandamus is found to be infructuous or fruitless, it may be dismissed on the ground that if the act against which this writ is sought to be issued has been completed, the issue of writ will be fruitless and the court may refuse to issue it. And lastly, the writ may be refused on the ground of misstatement or suppression of material facts in the petition. And now we'll discuss against whom such writ of mandamus will lie. The writ of mandamus may be issued by the Supreme Court or the Supreme Court or the High Court to the government, inferior court, tribunal, public authority, corporation, or any other person having public duty to perform. Mandamus will not lie against a company which is incorporated under the Indian Companies Act and has no statutory duty or public duty to perform. It may be issued against a private individual or a private body if the duty cast upon the individual or body is of a public nature and against whom it does not lie. That the mandamus cannot be issued against the President of India or Governor of a state for the exercise and performance of the powers and duties of his office or any act done or to be done by him in exercise and performance of those powers and duties when the High Court or the judges thereof acts in judicial capacity as distinguished from administrative capacity. The writ of mandamus cannot be granted against the High Court or the judges. The writ of mandamus also cannot be issued against a private individual or private body unless the private individual or the private body has been vested with a statutory or public duty. It cannot also be issued against a company which is incorporated under the Indian Companies Act and has no statutory or public duty to perform. It cannot also be issued against the legislature so as to command it to enact a particular law which it is competent to enact or to prevent it to enact a law even where it is going to enact a law which, if enacted, will contravene the fundamental rights or any other provisions of the Constitution. And those who are eligible to apply a writ of mandamus, so any person who is affected by the violation of the statutory duty or the abuse of the statutory power may apply for the issue of the writ of mandamus. The person whose right has been violated may apply for mandamus. The petitioner should have legal right to compel the performance of the public duty cast on the opponent. So, this is all about the writ of mandamus, and in our upcoming video, we will definitely discuss regarding the next important writ, that is certiorari.